I'm going to be speaking next to Kelly Khumalo's lawyer, Magdalene Moonsamy, who's joining us now. Ms. Moonsamy, good afternoon. What's your reaction to what happened in court today regarding the second docket 375 that implicates your client, Kelly Khumalo, in fact saying that she plus the others who were inside the house at the time of the shooting and killing of Senzo Meyiwa should be charged?
Look, the first thing is that the issue of the 375 was raised on numerous occasions by Defense 1 to 4. And that is a bit of a perplexing issue because if you ask then why when this state prosecutor had presented at the onset the issue of jurisdiction by the NPA, there was no question about it. It was accepted by both Defense 1 to 4 and Defense 5. So the issue of jurisdiction should have then been questioned on the basis of this 375 docket.
Are you saying whoever prepared, whichever jurisdiction prepared docket 375 would have been the one, therefore, to deal with it if the questions had been raised, because North Gauteng High Court in Pretoria is dealing with a different docket?
What I'm saying is that had that submission been made, remember that the state prosecutor made the representation in court on day one regarding jurisdiction. And it was then, there was no questions asked in respect of why not Johannesburg, but Pretoria. Everyone acceded to this docket, to the jurisdiction of the North Gauteng High Court having jurisdiction over the matter. Now, there was the 375 raised by Defense 1 to 4 on previous occasions, but not within the context of jurisdiction. So for me,
sorry, Ms. Moonsamy, just to clarify, I'm not a lawyer, I'm a layperson. What importance or relevance would a jurisdiction have in terms of docket 375?
Exceptional importance. Jurisdiction is one of the most important aspects in court. That's the one thing we all understand. If the jurisdiction of the court was accepted to be that of North Gauteng, then there must have been an issue regarding 375. And that's why we're on 636 in North Gauteng. We do not know the content of the docket. We need to understand what the implications of the docket are.
So you've never seen it yourself? You've never seen it yourself, although your client is somehow, we understand. I have not seen the docket as well, 375, that she was supposed to be charged along with the others. You also have never seen this docket?
No, sir, I've not seen the docket. However, there was a point when Defense 1 to 4 sent me a submission that he had made regarding representations for stoppage of prosecutions in terms of the Criminal Procedure Act, where he has made his own submissions and his own observations that he sent to myself. The content of the docket is not known to myself, neither is it known to my client. Over and above, we have never been approached by the state, by any of its apparatus, by the police on 375. We have been compliant on 636, but 375 has not been part of our cooperation, knowledge, etc.
Now, how do you respond when you hear your client's name being mentioned again in court today in relation to this docket that you've never seen, and proceedings have now been adjourned, postponed to next Monday?
Feelings are not at play here. We need to know the facts that are in that docket. So once we understand the facts of the docket, which we will be requesting from the state prosecutor, and as I said previously, our formal submissions, we will then be able to establish from that point what the facts are and how do we proceed with those facts, and whether that docket was really then one that was officially authorized and verified. So it's not about feelings, sir, in this matter.
Okay. When are you writing to the prosecutor? When are you requesting docket 375?
I will be requesting as soon as the end of this week. I will be requesting 375, and I will also be making further formal submissions with regard to the fact that upon jurisdiction, in court proceedings, the first point of departure is jurisdiction. Whether it is quantum or in a criminal matter, it would be what was the scene of the crime and why was the docket then in Pretoria. So if this is the case, that should have been raised as a fundamental point of dispute by defense 1, 2, 4, and 5, because jurisdiction is critical in proceedings.
Okay, so just may I ask you then this, you are not allowed to be representing your client or with that listening brief, let me calling that. I don't know, I don't remember the proper legal words that is used. In court, you are outside, you are following the proceedings.
Indeed, I am.
How is your client feeling today?
My client is always in good spirits. We were together yesterday discussing what we will be anticipating in terms of the way forward. She's always in good spirit. She's been waiting for her day, and I've said this, I think, ad nauseum. She's been waiting for her day in court. She's been anticipating, and she asked me again yesterday, why was she not first called as a witness to be able to provide evidence, because she was present as an eyewitness at the scene, So for herself, she's anticipating her day in court to provide the evidence that needs to then show value in terms of corroboration with whatever has been presented by Sergeant Musia. So indeed, I do not believe that she is in any way lacking confidence. She's fully understanding the realities that I play, but she's also insisting that she wants to have her day in court.
And that day in court will be as a witness, a state witness, or what? Just enlighten me, Ms. Moonsamy.
Okay, so initially when we had spoken to the state prosecutor requested for us to have an interview. That interview was subsequently set aside. They said there's no need. Your client may not be called as a witness, and your client is not a suspect. Now, this is not the first instance. There was an instance a few years ago when we went into an interview with ballistics, with forensics, and with the SAPs regarding this matter, which spanned multiple hours, and we were reconfirmed that my client is not a suspect in this matter. So at this point, it was only on the 23rd of April, if my memory can serve me perfectly well, that the state prosecutor presented in chambers, if I can put it that way, that my client will be called as a state witness, and hence, up until that point, my recusal will be temporary.
Okay, so you have to wait until to find out then what's going to happen on Monday. Just from your client, from your client's perspective, what would be a semblance of, I don't know if this is a right expression, a good outcome on Monday? Come Monday. I'm asking this against the background of this docket now that we're all hearing about, the second docket that you've never seen. You're going to be writing today to the state prosecutor to have access to that docket. What would be in your client, standing in a good state for your client out of Monday so that she can have a day in court?
Well, we can't preempt because we must first verify the authenticity of the docket. Even though something may be presented as evidence, it may not be that that was the process or that docket was then withdrawn for a reason. We can't speculate at this point. What we would anticipate is that our client be called in as a witness to give her evidence, to give her testimony as to what has transpired, and not be alleged to be. Because you see, the nature of the accusatorial process and allegation and not having the evidence and facts at hand are very critical in determining then what the process going forward must be. I want to reiterate my concern that this was raised prior by defense 1 to 4. But it has never been questioned in terms of jurisdiction almost 2 months into a trial. It's a concern, and it is a legal conjuncture that we have to find a way to cure, because that would be the first concern. If that was the case, that 375 is indeed the docket that is going to be relied on. Remember, sir, there are two things at play here. There's 636 and 375. It will then be at the discretion as to whether either of the dockets are then having information that is qualified to be either consolidated, alternatively, if they are going to be separated, and which one is then going to fall away. We can't make those presumptions at this point.
Okay, no, you make a good case. They will have to wait then and see what happens on Monday. Thank you very much for talking to us this afternoon, Ms. Moonsamy. It's good to see you as well that you're no longer wearing your neck brace that you were wearing last week. It means whatever had happened to you, you're getting better. That's Magdalene Moonsamy. She's a lawyer for Kelly Khumalo.